Can an oral contract be enforceable in the context of business disputes? The answer is yes, but with certain exceptions. If the contract involves the purchase or sale of real estate, that needs to be in writing. If the contract involves selling of physical things for $500 or more, that has to be in writing. If the contract involves credit or a guarantee to pay a debt, that has to be in writing. If the contract involves something that will be performed in more than 12 months, in more than a year, that also has to be in writing. Things that don't follow in that framework that I've mentioned, can be enforced even if there's no paper. But the reality is that in the context of litigation, when we are dealing with oral contracts, it becomes sometimes difficult to assess the terms. It becomes a little bit of a he said, she said situation, and sometimes it becomes a situation where a court may say that the terms are not specific enough, or there's not enough collateral evidence to assess the particularity of the details of that oral contract since there's nothing in writing. So it is possible, it is difficult. You want your contracts in writing, especially if you're dealing in business transactions, but it's not that all oral contracts are illegal. The law does allow or permits oral contracts. They can be valid and they can be enforceable.